And I think the American people need to better understand what that originalist philosophy could really mean for their everyday lives, because I think it means our entire modern understanding of certain constitutional commitments around liberty, privacy, and equality under the law could in fact be rolled back to 19th or even 18th century understandings in a way unrecognizable to most Americans. Many of these modern notions are rooted in a landmark case decided in 1965, Griswold versus Connecticut, where the Supreme Court held married couples have the right to use contraceptives in the privacy of their own home. In an interview just 8 years ago in 2012 on Fox News, Justice Scalia said this decision was wrong because under his originalist philosophy, there's no such thing as a general right to privacy in the Constitution. This is a question most currently serving justices have answered. When we spoke on the phone last week, you said you couldn't think of any specific issue of law where you disagreed with Justice Scalia. Do you agree with him that Griswold was wrongly decided, and thus states should be able to make it illegal to use contraceptives if they so chose?
Well, Senator, as I've said a number of times, I can't express a view, yes or no, A+ or F. In my other capacity, I get to grade, but not in this particular capacity with respect to precedent. I think that Griswold is very, 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 very unlikely to go anywhere. In order for Griswold to be overruled, you or a state legislature would have to pass a law prohibiting the use of birth control, which seems, shockingly unlikely. Right. And then a lower court would have to buck Supreme Court precedent and say, we're not following Griswold. Again, seems very unlikely. So I think that it's an academic question that wouldn't arise, but it's something that I can't opine on, particularly because it does lie at the base of substantive due process doctrine, which is something that continues to be litigated in courts today.
Well, just for the benefit of those watching, Judge Barrett, as I think you well know, your predecessors talked about Griswold in detail. Chief Justice Roberts said he agreed with the Griswold court's conclusion. He shared your view that he's comfortable commenting because it doesn't appear to be an area that would ever come before the court. Justice Alito, Justice Kavanaugh said essentially the same thing, that they'd agreed. In fact, Justice Kagan, who you've been citing on the no grading, said, I do, that she's willing to speak to it. And as every nominee has, I do support the result in Griswold. I understand that you're saying to us you're going to be your own justice and that you're very hesitant to talk about this case because it is an anchor to substantive due process. But let me just one more time say, are you unwilling to say, as so many currently serving justices have, that at least Griswold is not wrong?
I think Griswold isn't going anywhere unless you plan to pass a law prohibiting couples or all people from using birth control. And I think the question, because it's entirely academic, because it seems unthinkable that any legislature would pass such a law, I think the only reason that it's even worth asking that question is to lay a predicate for whether Roe was rightly decided, because Griswold does lie at the foundation of that line of precedent. Right. So because Griswold involves substantive due process, an area that remains one subject to litigation all over the country, I don't think it's an issue, a case that I can opine on, but nor do I think Griswold is in danger of going anywhere.
Well, and to be clear about what it underlies, it's not just that Griswold was a landmark case, as you well know. It anchors a lot of modern liberty interests in personal and family autonomy. It was extended to unmarried couples in Eisenstadt. It was extended to the right for women to control the reproductive choices in Roe and in Casey. But it was also extended to support same-sex couple intimacy in Lawrence v. Texas, and ultimately that same-sex couples have an equal right to marry in Obergefell. The reason I'm taking a few minutes with this is that Justice Scalia publicly disagreed with or dissented in each and every one of these cases. He wrote in one of these decisions that it reflected the court adopting the so-called homosexual agenda. And just last week, Justices Thomas and Alito issued an opinion stating the Supreme Court needs to fix problems from its holding in Obergefell. So I understand you'll be your own justice, and Justice Scalia's philosophy is significant, but I also think you've made it clear that it's largely your philosophy, and I'm trying to help viewers understand what it means to replace a Justice Ginsburg with someone who may more closely follow Justice Scalia's approach. But in this 2013 University of Texas Law Review article, which has also been referenced today, you wrote, and I'm quoting, "It's more legitimate for a justice to enforce her best understanding of the Constitution rather than a precedent she thinks clearly in conflict with it." Again, you're saying that if a Supreme Court justice thinks a prior ruling was clearly wrong, she should disregard precedent with which she disagrees, regardless of the typical balancing factors.
Senator Coons, with respect, as I explained this morning, that sentence has been plucked out of the article to kind of, I think, create a misimpression about the context. The whole article discussed reliance interests, discussed the reasons for stare decisis, and emphasized that courts ought not disrupt settled precedent, absent very good reason to do so, reliance interests being one. And I think that no one on the court, or even no one in this room, would think that the court ought never revisit its precedent. As I was mentioning, maybe it was to Senator Leahy earlier, you know, Bowers versus Hardwick held that certain sexual conduct between same-sex partners was illegal. It was criminalized. And then Lawrence versus Texas overruled that. And my guess is that you think Lawrence versus Texas was correctly decided. So I don't think, Senator Coons, that your position would be that no precedent should ever be revisited.
Correct. I do think in grievously wrong cases, it is appropriate to reach back, as a number of members have discussed around Brown versus Board and Plessy, and I did note that exchange earlier. But in terms of reliance interests and the significance of reliance interests, in reading that 2003 Colorado Law Review article, you wrote that reliance should count much less, if at all, when a litigant convinces a court that precedent conflicts with the statutory or constitutional provision it purports to interpret. I was struck by that language because I know you choose your words carefully. You've acknowledged reliance interests exist and they're part of the Supreme Court and its approach. But in this article, it seems to me you're giving your own views about whether reliance should matter. And you're unequivocally stating it shouldn't. It should matter less, if at all, when the originalist approach to reading the Constitution says this is wrongly decided. That's why, to me, the concern about reading the Constitution through a Scalia lens rather than a quite different, methodologically, Ginsburg lens. You've also recognized originalists like yourself are more likely to overturn precedent. In the Texas Law Review article, you cited statistics that self-identified originalists like Scalia and Thomas urged and joined in overruling precedents more than any other justices over an 11-year period. The disturbing picture to me overall about all of this, about precedent, is that I think there's been a movement amongst originalists and a change in terms of the approach of judges to judging who self-identify as originalists. In the 2017 article in the University of Minnesota, in Constitutional Commentary, that's been referenced before, you said, and I'm quoting, about modern originalists, that they've abandoned the claim one should be an originalist because originalism produces more restrained judges. Do you stand by that characterization?
Well, Senator Coons, I just want to point out that in this whole discussion, you know, I did write that Colorado article in 2003. I don't recall that sentence or its context, but in my full body of work, including everything that's come before, including the 2013 Texas Law Review article, I've written at great length about the virtues of stare decisis and the stability interests it serves. And in my scholarship, I've also talked about other features of the judicial system. Right. And also, I'd like to point out that nothing in my record in the Seventh Circuit shows disrespect for stare decisis. And also, Justice Scalia did observe and follow precedent. It's not like Justice Scalia ever advocated an overthrow of stare decisis. So I just don't think there's any evidence to suggest that I'm in there trying to burn up the 600 volumes of the United States reports that are on the shelf. I don't have an agenda in that regard.
Well, that's so exactly what caused me concern as I looked at Thomas versus Scalia, and which may be more the role model you follow in terms of the application of stare decisis. These quotes jumped off the page. I haven't made a practice of reading 50-page law reviews recently. I don't mean to suggest
recommend it.
they were compelling and well-written. But these quotes struck me as clear statements of a view or an intent. And as I've said before, the larger challenge here is not what you've said about your views on cases, but what the president who has nominated you has said about his goals and his objectives for your service on the court. And frankly, my concern about originalism and an activist willingness to reconsider precedent is that in combination, Justice Scalia's views, often expressed in sharply worded, memorable dissents, may make for great academic reading, but I think most Americans don't expect them to become the law of the land. And in a long line of cases, they would overturn well-settled precedent that I think we have all come to expect. So my core concern here, Your Honor, is that your confirmation may launch a new chapter of conservative judicial activism, unlike anything we've seen in decades. And the point of the chart was to just show we've mostly been talking about the Affordable Care Act and privacy-related cases. But if that's true, it could touch virtually every aspect of modern American life. I pray that I'm wrong. I hope that I am. But in my reading of your work, nothing has alleviated my grave concerns that rather than building on Justice Ginsburg's legacy of advancing privacy and equality and justice, I'm concerned, in fact, you will take the court in a very different direction. And so with all due respect, I will be voting against your confirmation, Your Honor. Thank you, Mr. Chairman.